13. Court procedure. Just as the principles of criminal law were crystallized through the years, so a criminal procedure was developed which controlled the processes by which one accused of a crime was arrested, tried, and punished if convicted. The criminal procedure of the common law which was in effect in England was the result of many centuries of development on the continent, and was brought to this country by the early settlers. It was very harsh and oppressive and gradually was changed somewhat to meet the customs and usages in a new country. Nevertheless, the criminal procedure of the common law is still the backbone of our present system. The arrest and preliminary hearing. The first step in the process is usually the arrest of the accused person. A warrant which has been issued by a magistrate upon the sworn statement of the complainant is generally necessary before the arrest. However, an officer or even a private individual may make an arrest if an emergency exists, namely, if a felony has been committed or there is a breach of the peace and the safety of the public is endangered. The warrant may be called an order which allows the arrest, and it must state exactly the nature of the charge and the name and description of the person. This rule is so strictly followed that when a person was arrested upon a warrant charging that he did unlawfully, willfully, and feloniously assault another with a deadly weapon with intent to kill, he could not be tried on a charge of assault with a deadly weapon. The decision was that the court had no power to permit an amendment of the warrant and so change it to charge a different offense. In an early New Hampshire case, a writ directed the arrest of one George Melville but was served on George Meldon. He brought suit for false imprisonment and obtained a verdict in his favor, for it is a well-settled rule that anyone who causes another to be arrested by a wrong name is a trespasser, even though the warrant was intended for the person actually arrested. The law affords protection to all persons, whether guilty or innocent, and concedes the accused the right to a speedy trial. If the crime is a minor offense which is within the jurisdiction of a magistrate or police court judge, the matter can be disposed of quickly and a fine or other punishment meted out. But if the offense is a major crime, as murder or misappropriation of funds, the preliminary hearing determines only the fact of sufficient evidence to prove a prima facie case. In the latter event, the prisoner must then await further proceedings, either in jail or out on bail. If bail is allowed, a bond is filed to assure his appearance for further examination, and if he fails to appear as required, the money is forfeited. The bond should be sufficient to ensure the appearance of the accused in court, and it can readily be seen that it must be large enough so that it will not be less burdensome to escape and forfeit the bail than it is to stand trial. It is also evident that bail cannot be allowed in certain cases where the risk of escape is too great. The individual must then be kept in confinement until trial. The trial is sometimes delayed for several months, depending upon the frequency of the terms of court and the crowded state of the docket. Indictment by the grand jury. Before the actual trial, the individual must be formally accused of the crime, usually through indictment by the grand jury. This jury consists of not less than 12 nor more than 23 persons who are chosen at large from the county having jurisdiction. Blackstone said some should be picked from every 100 and added, they are usually gentlemen of the best figure in the country. The jury is impaneled at the opening of the term of court, is given a few instructions by the judge, and then retires to carry on its deliberations. The sessions of the grand jury are private, and no one comes before this body except the witnesses, who usually appear singly, and the prosecuting officer, who is the district attorney, state's attorney, or county solicitor. This official holds a very important position, both before the grand jury and later at the trial, for he is the one who conducts the prosecution in the name of the state or commonwealth. He prepares the case and presents the state's side, examines the witnesses, and admits only legal evidence. Though he must not express an opinion or take any part in the discussion in order to influence the jury, he may advise as to the law. At least 12 of the men who make up the grand jury must agree in finding a true bill, which means that they believe the charges stated in the bill and that there is sufficient evidence against the accused to justify a trial. This is endorsed as a true bill, and when the jury has finished its work, all true bills are handed to the foreman of the jury, who files them with the clerk. The bills then become indictments. Though the arrest of the offender usually takes place before the indictment, it is sometimes advisable to secure the indictment first. For instance, if a young girl has been the victim of a sex crime, it is a desirable method of procedure as it eliminates one appearance in court and makes a trying experience a little easier for her. The time element is also important sometimes, particularly in states which have few trial terms of court. For a case that has been brought to the attention of the prosecuting officer at the last moment can be brought directly before the grand jury, and consideration by the lower court eliminated. Language of the indictment. The indictment must be clear and certain in its language as to the charge against the accused, or respondent as he is called. It must set forth the name exactly so there will be no question as to the identity of the person, and it must state the offense and allege a date. At common law, it was not proper to allege on or about a certain date, though this is permissible now by statutes in many states. For example, the date alleged in a case of rape does not have to be exact, thereby allowing the prosecutor attitude in proving the fact without being bound to prove the exact time, if the date is essential in proving the offense, as it is if liquor has been sold on a holiday when it is forbidden by law. It must be stated exactly. The exact description of the premises is necessary when arson or burglary of a certain place is alleged. This accuracy is to assist the accused in order that he may know what to prepare for a defense, as time or place are often important in proving an alibi. The conclusion of the indictment charges that the offense was against the peace of the state. The arraignment and pleading. Up to this point, the accused has had a hearing in the lower court and been held for the grand jury, which brought an indictment against him. But there is still a possibility that he is not guilty. The law presents everyone innocent until proven guilty. At the arraignment, which is the next step, the accused is given an opportunity to say whether he is guilty or not. He is brought into court. The accusation contained in the indictment is read to him, and he is required to answer it by pleading guilty, not guilty, or nolo contendere. By means of this last plea, he does not admit his guilt directly, but tacitly admits it by throwing himself on the mercy of the court. If he answers with a plea of guilty, the judge can sentence at once. But if the plea is not guilty, an issue is formed, which indicates that a fact is affirmed by one side and denied by the other. The case then goes to trial before the jury. Trial by jury. The petit jury before which the case is tried has nothing to do with the grand jury. But here's the evidence presented by both sides and bases a verdict upon this. It is supposed to be an impartial body, and the 12 members of the jury must bring in a unanimous verdict, null prosing a case. At any time before the trial, the prosecuting attorney has the right to null pros a case if in his opinion the state cannot prove the allegations. For example, if the main witness for the state is a feeble-minded girl and the attorney feels doubtful of her credibility as a witness. This is usually done only after consulting with the court, preserving the rights of the accused. There are various methods of procedure for preserving the rights of the accused, among them change of venue. This is allowed when there is such prejudice against the accused that he cannot secure a fair and impartial trial in the county having jurisdiction. The trial is accordingly transferred to another county. In a recent case before the Supreme Court in Texas, a change of venue was denied because the application was supported solely by the affidavit of the defendant before his counsel, and did not show that he would be denied a fair trial. The accused has a right to be defended, and the state may appoint a lawyer if the accused cannot afford one, though a counsel is not always provided unless the crime is a serious felony. Attorneys may bring various motions which will delay the case. For example, they can claim irregularities in the grand jury procedure, either that the facts stated in the indictment are untrue or do not constitute a crime in that particular state, or that the court does not have jurisdiction. When all the evidence has been presented, the final steps are the verdict by the jury and the sentence of the court if the accused is found guilty. Sentence. The punishment may be a fine or imprisonment or a suspended sentence, and in some states the death penalty is still in force for certain crimes. It should be understood that the jury does not pass on matters of law, so the sentence is imposed by the judge. The accused is in court and he may state any reason why the sentence should not be imposed. In most criminal cases, there may be an appeal from the decision as in a civil case. If that accused has been acquitted or convicted, a well-known rule, called the plea of former jeopardy, protects him in the future, for no person can be tried twice for the same offense. And so, if he has been indicted, tried, and either acquitted or convicted, this may be set up as a defense to prevent further prosecution. What will constitute the same offense is sometimes a matter of doubt. But the test commonly followed is, could the accused have been convicted on the first indictment by proof of the facts alleged in the second? For instance, a man was indicted for killing another by shooting and was found not guilty. He was then indicted and convicted for killing the same man by striking him with a gun. This conviction was held proper, for the evidence necessary to sustain the second indictment would not have been proper under the first, so he was not placed in jeopardy twice for the same offense. It is presumed to be for the interest of society as well as the individual that there should be an end to the controversy. Hence, there are statutes barring a prosecution unless it is started within a prescribed time, which varies according to the offense. Conducting a civil case. The steps in the trial of a civil case are not the same as in a criminal case. The parties to an action of this sort may be individuals or corporations, and the state as an entity is not a party. When one contemplates legal action, he should consult an attorney as to his rights. The attorney will get all the facts which have to do with the case and eliminate those which have no legal significance. For example, in the case of an accident, it is important to know who saw it and all the relevant facts to which the law can be applied, such as the time, place, and persons connected with it. If the plaintiff's attorney decides there is a good case, and notice is served on the defendant, who is the person against whom the claim is brought, to appear in court at a specified time. This brings him under the jurisdiction of the court. At the hearing, if no case is established, the matter is ended at once. It may also be ended if the suit is for a small amount of damages and is within the jurisdiction of the magistrate or police court. But if the decision is adverse to the defendant, he may appeal, and this transfers the case to the regular trial court. Or it may be started there in the first instance by filing a summons or writ and a statement of claim. The defendant files an answer so that, as in criminal procedure, an issue is formed, and it is upon this issue that the trial proceeds, either before a judge or a judge and jury. The facts of the plaintiff's claim are first presented, and if a case is made out, the defendant proceeds with his answering testimony. The jury determines the facts. The judge applies the law to them. And the verdict, which is called a judgment in a civil suit, is handed down. The execution is the final process unless the losing party takes an appeal from the judgment of the court. This procedure may be somewhat simplified, but it is essentially the course of action in following a civil case through the courts.